Good afternoon and welcome to the House Judiciary Committee. And this afternoon, we're going to be going over the changes to S-109 with Eric Fitzpatrick. I think we're just going over the changes, right?
Yes, I think so. That's what I understood as well.
Right.
Thank you, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as the chair mentioned, to go over some proposed changes to S-109, which is the annual miscellaneous judiciary procedure bill. We've already done the walkthrough of the first chunk of the bill. And now the proposal is to make a couple of changes and add a few new sections. So all these changes are highlighted and they begin on page 18. So everything up through page 18 is identical to the way it was as it passed the Senate.
Two questions.
Yeah. I didn't see.
No, that's okay. Ian had his hand up first, but I vocally said something. So it really should go to Ian, but I appreciate you let me go first. These were changes added by who, Eric?
Proposed by the chair.
By the chair. Okay.
Yeah.
Thank you.
Yeah, absolutely.
Before we get past
So they're not added yet. Proposed only.
proposed only by Martin.
Exactly.
Okay.
Yeah, then you guys decide whether you want to do it or not.
Before we move past page or to page 18, on page 15 and 16 is this really great stuff around the powers of attorney. And I think we kind of landed on it being necessary to add in the new proposed subsection F that starts on page 15, that we add at the end the same carve out for fraud or forgery language that you see at the end of the other subsections. So if you look on page 15, line 14 and 15, this subsection shall not apply to power of attorney obtained by fraud or forgery. So having that also in the new proposed subsection F. I'm pretty sure that we talked to the witness and everyone was kind of in agreement.
Okay, great. Thanks.
Am I accurate in that?
I remember that.
Okay. We can run it by Martin as well, but
Sounds good. I jotted down though, so
great.
I'll keep it handy. You to add if that's the way you want to go.
Okay, sorry to interrupt you.
Yeah, sure.
I got one more. Oh, sorry, Ken.
So, well, I guess this is what we do with these bills. We go from 20, now we're at 31. We'll probably be at 71 before we're done, right?
They do tend to increase rather than decrease. That's true.
That's why I raised my hand and I got thinking about it. It's like it makes sense. So I'm good. Thanks.
I'm gonna sound foolish, but what are you saying? I just want to understand. I didn't understand.
It went from, when I first glanced at it, I see it was only 20, the first part. Now we're up to 31 and then.
Oh,
it's like-
sections.
Yeah.
Oh, okay.
Not sections, just pages. And
Okay.
then it's gonna keep growing because it's a
Miscellaneous.
miscellaneous bill. So-
Yeah, not unusual at all.
No, and I knew that.
Could still grow a little more before the end of the year.
Wouldn't be unusual.
And Zach,
Sorry, I just have one more.
Yeah.
When was this language released?
Oh, I think last night or this morning. I can't remember which.
It should this morning.
Okay.
That's all. Thank you.
All right. Shall we look at the proposed changes? All right. Yes. All right. So let's begin. As I say, not trying to skip over those first 17 pages, but there aren't any proposed changes there. But feel free to jump in if there are any other topics about what's passed the Senate that you want to look at. Possible changes to the Senate version begin with Section 25, page 18, and this is the Firearm Surrender Order Compliance Working Group. Now, remember, this is the working group this was requested by the Vermont Network, the Network Against Domestic Violence, and the Domestic Fatality Review Commission. And the idea that the reason that they're requesting this is because there are a number of different provisions in Vermont law that provide for surrender of firearms under different circumstances. The relief from abuse orders, for example, domestic assault arrests, the ERPOs, the emergency risk protection orders, they all have these authority for law enforcement to take custody of firearms for certain periods of time. So this doesn't propose to change any legal authority of anybody to do that. The proposal is that they want this committee to study, and it's lines 4 and 5, develop a uniform process to ensure compliance with court orders to surrender firearms. So in other words, when you have this pre-existing authority of the court ordering firearm surrender, try and develop a uniform process. So there's not these different procedures and processes in different statutes, which currently there are. And that's the idea. That's the big picture idea. What are the proposed changes? A couple of language changes in the first subsection. You'll see just some tweaks that providing that the working group shall examine what policy changes are necessary to create this uniform process for storing surrendered firearms pursuant to court orders. That was should have been included in the first place because this is all about surrendering them pursuant to a court order. And then there's been some proposed changes to the membership of who is this working group. And you may recall that in the draft that came over, this working group was quite large and it had 16 people. So the proposal is to cut that back and have it only be 8 people. Those same 8 people are also 8 who were in the original working group. But then rather than have the working group be that big, you'd have you add a list of people to consult with over on page 19. So these folks wouldn't actually be on the group, but the group would have to consult with. So the idea, I think, is to streamline a little bit, make the size of the working group a little more manageable.
Eric,
Yeah.
I'm not sure, you may know, I know there had been some talk about the Vermont Federation of Sportsmen Club actually being in the working group.
Thought they were, oh no, I see, they're on the consultants now, they're line 10, yep, yeah, that was the proposal, but again, where it is you want, if you want sort of mix and match, right? Where it is, if you think that they would be better off on the working group, you can certainly make that change or propose that change, but yeah, they are listed, line 17, page 19 as one of the parties to consult with, but you may want to move them to the group, yep.
Yeah, I think it's worth a discussion anyway.
Right. And so, yeah, and there are a couple of parties that were added. Most of the ones in the consulting list over on page 19 are the same, but there's a couple that are added. I think the firearms licensees in line 13 is new, and the number and subdivision 5 advocates from culture-specific advocacy organizations that work with domestic violence victims. I think ATF was also new. I don't think ATF was in the one that came over from the Senate. Other than that, that's the only differences so far.
Eric, just a quick request, as you
Yeah.
go through this, if there is a corresponding House bill to these,
Yes.
can you just flag that for
I
us?
will,
Just
definitely.
so I'm aware of what we're grappling with.
Yeah, exactly. Yep. They will go find several of those.
Yeah, but that's what I'm just trying to parse out.
Yeah,
So,
yeah, sure.
what's new and what is coming from stuff that we've already
Yep.
entertained.
Exactly.
Personally on.
Sounds good.
Thank you.
Sure. Any other questions on the working group?
Go ahead.
Can you just run this by me? The membership and then the two different, the working group and then what's the other one called?
Well, the other one, they just people that the working group has to consult with.
They'll be witnesses, basically.
Right.
But they would, but they'd have no say in it.
They wouldn't be able to make a decision the same way members of the working group would. No, they would have to be consulted with, listen to their testimony, but ultimate decisions are with the group themselves.
So I'm just looking at the two lists and I'm not, for lack of better word, I'm not seeing anybody in the working group that is actually pro-gun, for lack of better words. I said lack of better words. I don't know what the proper would be, like, I'm surprised public safety isn't over there.
They are. They are. Well, actually, interesting. So thank you for mentioning that one. I should have I meant to mention this, Department of Public Safety was on the membership list. But they requested to be struck because this is at their request, because they said they didn't oversee firearms storage programs. So they suggested adding a federal firearms licensee to the consultants instead, which is done over on page 19. But to your point, Representative Gosselin, you certainly could, if it's up for discussion still, if you wanted to add, say, numbers on the consultant list, number 6 or 10, maybe you want to have one of those or both of those folks be in the group as opposed to the list of consultants.
I screwed that up. I see on line 5, that's where the consultation, or
Oh, yes.
that's where that started. So they were there. Okay.
Yeah.
But you're telling us that's no longer the case, is that in the next iteration, they're going to be struck? Which is self-selection, public safety.
Maybe I thought are they there? Do you see them somewhere?
No,
Yeah, I meant to strike them.
you did.
Okay.
Yeah,
Yeah, they were originally,
they do appoint a member from the state police.
Yeah.
right.
They're represented.
Oh, I see. Yeah. In the previous iteration, over in the list of membership, the commission, you see how like it'll have like.
The commissioner of public safety.
Exactly.
Right, or designee.
Yep.
Yeah, that's what I was getting at.
Yes. And then they asked to be taken off.
Right.
So.
And Chris Bradley will be in tomorrow. They let me know.
Right. And he's the Federation of Sportsmen Club, right? More questions on this section? All right, so moving on to section 26. And this one actually, as Representative Harvey was getting at, this section 26 was H7. So this is a bill that the committee has, I think, still on the wall.
Yep.
And I don't know if you've taken testimony on it yet or not, but because Michelle's bill, so she would have, and she didn't, I asked her, she didn't think so, not when she was here. So the gist of this bill, interestingly, all this does is it actually reinstates language that was repealed in the miscellaneous bill last year. So that language is over on the top of page 21, subdivision A. And what happened last year was that, interesting, I checked this date, almost a year ago exactly, April 12th of 2024, the miscellaneous bill was down in Senate Judiciary at that time. And DCF, Department for Children and Families, asked for the repeal of some language, and it's verbatim, exactly what you see on the top of page 21. They asked for the repeal of that, the rationale being that, and this has to do with termination of parental rights, right? When is the decision made to terminate parental rights? And DCF said, well, we don't, a parent's economic status there is not something that's taken into account when you're talking about, whether or not parental rights should be terminated. That non-payment of child support, for example, is basically someone's economic status. That's not taken into account. Therefore, it should be repealed. And so it was struck. It is a good lesson in repealing something late in the game without hearing from any witnesses. Because then what happened was, over the summer, started hearing from practitioners that, well, actually, as it turns out, the whether or not a parent has paid child support in the past is actually a relevant factor sometimes for the court to be considering when they're talking about whether or not the parent has exercised parental responsibility in the past, for example. That could, not that it's the dispositive reason, but that might be relevant. The court's thinking about the existing statutes, and even on existing language, sorry, page 20, the bottom, the court's supposed to consider all relevant factors about whether or not the parent exercised parental responsibility. So practitioners brought that to the attention of our office, actually, and that's how it ended up in H7. The idea being put the language back in. I think that you're going to hear from some witnesses about that exact issue and why it is that language should be back in statute where it was until last year.
Who are the practitioners?
I believe that's Mr. Hughes. That's one of them.
Oh, okay.
With a T.
Yeah.
Is this the identical language that would have been in this title?
I believe it is. I double checked that this afternoon. I thought I was moving pretty quickly, so I may have overlooked a word or two here and there, but my my look at it was, it looks like it was exactly.
You're side by side of, yeah, cool.
Right.
Great.
Yeah. Any more questions on that section? All right, so the next one, section 27, also a bill up there, H 108 is this one, section 27. This, and I think Michelle said that you guys had heard some testimony on this, or at least she had done a walkthrough of it. And this is a bill that repeals the criminal penalty for the failure of an adult child to support the adult child's parent. The parent is destitute and unable to support themselves. They're pretty old criminal statutes that, from what we understand, has rarely, if ever, actually been used. And it doesn't repeal the whole statute, just the language that does that. You'll see that on lines 15 through 18. So the idea is this criminal penalty for an adult not providing support to the adult's parents who are destitute is repealed. All right. Next, now we move on to sections 28 and 29, which are over on 22. And these sections are also in a current bill, which is H6. Yeah,
It's in Ways and Means.
oh, it is. All right. It's because I didn't see it up there anymore. So yeah, so is that already passed out of committee, in other words? Like it's up there because, oh no, and that's where it got referred to, because it's a fee.
Yeah.
I see. Gotcha. All right.
Which one is this?
This is two sections, 28 and 29, that's lines 4 through 10 on page 22.
That's H6.
Exactly. Yes. Now, what does H6 do? What it does is, a couple of years ago in 2023, the legislature passed an increase on the fee for marriage licenses. And that fee went from $60 to $80. And of that $20 in increase, $5 of it was retained by the town clerks, and $15 of it went to the Domestic and Sexual Violence Special Fund. So that's what happened with that extra. And some of that, that's an increase in what the parties already get. They weren't getting, starting with zero. For example, the special fund was getting 35 before, and they get 50. They got 50 after the fee was raised. So when it was passed, though, in 2023, it had a sunset. It was only going to remain in effect until, you see line 9 and 10, until July 1st of this year. So it's supposed to be repealed this year. This proposal is to repeal the sunset. So the fee would remain as it has been for the last 2 years. At $80 rather than 60.
So I don't remember, is the miscellaneous bill usually used for sunsets? Because I know we usually have like a sunset bill. I mean, so remember, right, you're the guy that goes through and finds all the sunsets.
Well, actually,
Or is this
we have done,
happens to be?
no, usually more often, we have done the sunset bill a couple of times. Most often they end up in the miscellaneous. bill.
Okay.
Yeah. But it can be either. There's no wrong answer, but most often I'd say miscellaneous.
Because since I've been in here, we have done a sunset bill, I think.
Not every year. Couple.
No, not every year.
Right. Yeah. Yeah.
It's been a few, I think, since we've done one.
Yeah, it's true. Yeah. Maybe it sort of depends. Once you hit sort of a critical mass, we put it in separate bills. I'm not sure how many, but sometimes they end up here too, and that's where this one is up. No. All right. Questions on that piece? All right. So now section 30, page 22. This goes on for a few pages. This has to do, there's a provision in current law that creates this expedited appeal process for situations where a person is detained, or they are held without bail, or they're held on conditions of release. And there's this particular type of appeal process where it can be brought to a single justice of the Supreme Court, or sometimes to a panel of 3 justices of the Supreme Court, depending on the circumstances that arise. And the proposal here is to add one more situation in which this expedited appeal process can take place. And that's over on, I should forget this, starting on page 23. So right now, subsection C at the bottom of page 23, one of the situations in which this expedited appeal process can happen is the prosecutor can file an appeal when a person, an offender, is released with or without conditions. So in other words, the prosecutor might say, well, no, I don't think that person should be released, or I think the conditions should be different. So they can file this appeal. This adds a similar kind of thing over on page 24. What about when there's the prosecution files a request to revoke bail? So for example, they might allege the person violated their conditions of release. I'm going to file a motion to revoke bail. Court denies it. That's the case. Then this adds the ability of the prosecutor to file one of these expedited appeals. They can file to, I believe it's a single justice in this instance. Yes, it is a single justice of the Supreme Court, an appeal to that decision that denies the motion to revoke bail, so they can have it reconsidered by the Supreme Court justice.
Is this an existing House bill? Or was it?
No, I don't believe so.
Or anything?
Not that I know of. I think it was, I'm trying to remember. It's definitely not an existing House bill. I'm trying to find anybody suggested it or if it was.
So I can-
It strikes me as familiar.
Yeah, no, I can,
Rings a bell, but I can't remember
so
where.
it was, 410, I think, page 410 or 49, 409. 409, which is a bail revocation bill. We had various, witnesses testifying. Subsequently, one of the issues we identified was a difficulty of appealing a denial. And the Department of State's attorneys provided some proposed language, which went to Ben. Am I remembering this right, Kim? Went to Ben Navigroski, who did this language. So that's where it came from. Ian.
And I think if I understand, it's kind of unclear whether you can appeal a denial of a bail revocation motion right now in the existing law. And that this just really clarifies that you can appeal a denial. Is that accurate?
It definitely makes it express.
Yeah.
Quite clear. The language now is quite
It's very
clear.
express.
Yes,
Okay.
yeah.
Right.
Yeah.
Go ahead.
Any other? That's okay. So the next two sections, which start at the very bottom of page 24 and go on for the next couple of pages. These next two sections also not in an existing bill, but these were requested by the Center for Crime Victim Services. So they.
Earned time isn't anything in existence?
Oh, no, I meant that it's not an existing.
No,
bill.
but I'm saying sorry.
Yeah.
First. Earned time is not language existing in the current bill because I'm almost positive that we considered something.
That maybe.
Or I saw it somewhere.
Maybe there was a bill that was, it could be, I know that the Center for Crime Victim
It's a
Services,
provision in something.
the underlying statute, absolutely.
Yeah.
And I'm pretty sure that they submitted this request to House Corrections as well. So that maybe you guys saw it in the course of that process as well, if
Okay.
possible.
So in this particular section, we're talking 31, corrections and institutions has to look at that part as well. They're also going to be taking up that one section.
Okay.
Yeah.
Do they have something on the wall that has this language?
I don't remember if they do or not, or if it just came up. I don't remember where.
I'm not aware, but I am aware that they had some, and maybe it was distributed. There was a request from the Center for Crime Victim Services. with
Right.
Proposed language.
Yeah,
So it wasn't in the bill that I know, but at least there was proposed language. Although I changed it a little bit.
Yeah.
So it may not look quite as the same.
No, that's what
Yeah. So the idea, though, at least of section 31, before we get to section 32, section 31 does deal with, as Representative Harvey was saying, with earned time, which is the system that's in place. Used to be called good time. Now it's called earned time. And the idea is that it's a system where the defendant earns 7 days in their reduction of sentence, basically for every month of good behavior, for lack of a better term. There are no disciplinary violations, no violations of conditions of release, that sort of thing. If they do that, they can get 7 months off their minimum and maximum for every 30 days that they go with that sort of clean record.
Seven
Now-
days,
Pardon me?
7 days.
Yeah, what'd I say?
7 months.
Oh, yeah, that wouldn't be a fair proportion.
I was like, yeah, 7 months total.
All right. Yeah, 7 days, sorry. So, and under the existing procedure, victims have some notification rights that in the existing statute. This proposes to add a couple of changes to the victim notification rights, as I say, and it was requested by the Center for Crime Victim Services themselves. So the victims are asking for this. First one is, you see it's in subdivision B. Right now, when an offender gets one of these earned time reductions, so if they get the 7 days off their maximum minimum, they have to get notice from the Department of Corrections. Look at line 9, not less frequently than every 90 days, anytime they get this reduction. So that's existing. This proposes to add the victim to that if the victim opts in. So they're providing that notice not less than every 90 days to the offender. If the victim opts in, they get the notice too. That's the nutshell. That's change number 1.
I don't know if you know this, Eric, but is there a process already in place for the victim to opt in? Or a victim to opt in?
I don't know the answer to that. That's something I think my DOC might be able to
Okay.
My understanding is that DOC supports the concept, but I'm not sure about that process. And I do know that at least the second change you'll see, and that's down in subdivision B. This is a separate sort of information, providing of information to victims. This provides that under existing law, that victims who want, in other words, they want to be able to have this information, they can see changes in the scheduled release date of an offender. That's the existing law. My understanding, you hear from your witnesses more on this, was that DOC said that that language wasn't really working because the scheduled release date changes so much. So they wanted a language change there. Instead, they make that information available to victims of the offender's minimum release dates if those change. So changes to the minimum release date, which I guess is more identifiable. So that's that one. Next one starts at the very bottom of line, page 25, goes over onto the next couple pages. This is also a request from the Center for Crime Victim Services to create a victim notification system task force. And the idea of this task force, you see over the top of page 26, lines 2 and 3, to review and improve the responsiveness of Vermont's victim notification system. So there's a lot of situations in which victims have a right to receive notice and also to appear in criminal proceedings. You know, they have a right to make an impact statement, a victim's impact statement, for example. They have a right to receive notice of various status changes in a criminal case when certain things happen, and they have notification rights. And I think the idea here is to not to change anything about when they receive notice, but to improve the ability of victims to receive notice, the responsiveness of the system, the efficiency of the notice provision system, and to create a task force to do that. You'll see that people on the task force are identified on page 26, lines 1 through 4, the Commissioner of Corrections, ED of Center for Crime Victim Services, and the Department of State's Attorneys and Sheriffs, and 2 people who are either victims or survivors who are appointed by the center. And the main task you'll see is identified there in subsection C in line 26. Task force is to study the current state of the victim's notification system, including improving the victim's accessibility to information, ensuring that the entire, oops, I see a typo there. That should be entire, not, I don't know, I spell check didn't catch that. Is that French, entre, like that, maybe? The entire notification process is trauma informed, including all notifications, communications, and informational materials. Expand the use of automated notification systems to increase options for victims, and any recommendations for necessary training and resources. So that's what the task force is going to be looking at.
I'm on, where is this? Line 13, page 27. They shall not meet more than 6 times.
Yes.
Why?
It's somewhat, it's in sort of our boilerplate's the wrong one, our model language for when we create task forces and studies. Sometimes has provisions for maximum meeting times. And so in order to keep expenses down, sometimes it's included. This draft language was actually worked on with Jen Pullman, who's the executive director of the Crime Victim Services, and Ben. And it includes, so I just cut and pasted what they had. So I don't really know, you know, it's not necessarily, it's not a requirement. And it may be that you don't want to have any maximum number of meetings.
I mean, that just seems like if the job hasn't been accomplished in 6 meetings, then why are we limiting it to 6? I mean, you already, I don't know if you do or don't know this, already have a gripe about working groups, but it's like, why are we adding like a maximum amount of times that someone can meet if the job's not done?
So I can probably answer that. I think is that appropriations, if there's going to be an appropriation associated with, and actually this one would, because
That's what I
that's
know.
two persons who are either victims or survivors of crimes appointed by the center. So we would pay a per diem to them. We wouldn't pay for people who are already paid. They're all the agency people. So because there are a couple people in here that would get a per diem, that's when we will put a limit. So that, because appropriations will ask us for that. You know, how many meetings are you going to have? Because we need to know how much this is going to be. So that's why that's. And Karen's nodding her head, so I must have gotten that right.
Yeah, I will say too, I've also seen where they have put in requests for extensions or asked for additional meetings or so. I feel like that has come up before increases, so.
Andrew.
Well, since, you picked up the first copy of it on line 16, page 26, there's a second that trauma informed is hyphenated compound noun.
Oh, thank you.
Adjective, sorry, adjective.
Was that Latin?
Modifying.
Where was that?
Process.
Hey, where was that? The current state? No, not that one, nowhere.
No, line 16, page 26, you need a hyphen between trauma and informed.
Huh?
Funny that both typos are on the same line.
Oh,
Bad line.
Yeah, I guess so.
Everybody's in agreement with my wow.
Yes.
You know, like capitalize like probate judge, guardian ad litem. Those are all
generic title.
they're generic titles.
Right. If you were like probate judge Ian Goodnow, you might capital.
Yeah.
That's right to it.
Or the probate division of the Superior Court, I found. So our editors anyway will capitalize that, but will not just capitalize a general probate division, right?
I have another question. It's just to the chair. Is this what we were discussing 2 weeks ago that it has to be unanimous to
That
get out of
is-
committee?
Yes. that is-
Okay.
So, we're flagging issues here, and I can hear that we have to, we're gonna hear definitely from additional witnesses on this as well.
I just want to make sure I was thinking about the right
Yes,
process here.
yep,
May I ask a question for that?
yes.
So if somebody does have concerns or questions, like, when is it good to let, like,
Well, I think we need to hear from witnesses, first, and we'll walk through and discuss the various sections.
And does that also go for things that other members of the committee want to include in the miscellaneous?
Yeah, I mean, anything that's in the miscellaneous.
Okay. No, but I'm saying like this is just a starting point. Like we're not,
Right, there may be other things.
there could be a lot more that comes into this.
Absolutely. And likely will.
No, that's what I'm expecting and would hope for.
Yeah.
Or if we have things removed.
All right, so the task force, it sounds like most folks have already looked at this. There's a report that has to come back by November. Talks about who calls the first meeting, as you're just referring to the maximum meeting number of times, quorum. The committee ends in February. Then there's the compensation reimbursement language that the chair mentioned, because there's members of the committee who are not state employees. And any other questions on that?
Just a general question. Does an appropriation just take a sum of money, kind of set it aside for study committees and task force and that type of thing? Karen shook her head, yeah, so it must be right.
I think that's what I remember hearing, but there is a limit to it, so they have
Yeah,
to
oh,
look
yeah.
up how many study committees and all things are there out
Right,
there.
right.
Make sure there's enough in the pot or whatever.
Right, yeah, there's a set amount in the appropriation bill for. Yeah. That study committee.
Yeah, there is, and
And they pick and choose
yeah,
in the end what goes through, without going over, I'm sure.
yeah, no, that's exactly right. I mean, so we'll have to, I mean, if this ends up in the bill, we'll end up being in front of, somebody will be in front of appropriations. And I know before the money from ARPA and all that, we had to fight if we had like $2,000. We had to go down there and testify and push for it back to my first 2 terms in here. And I expect that that's where we are again. Zach,
Who provides oversight over the working and study groups?
in what sense? I mean, I guess the oversight is that we get.
Like, for example, if someone submits expenses for, say there's an extension for the meeting, they have 12 different sessions, they submit per diem expenses for 12 different meetings, who actually is ensuring that, one, they attended the meetings, that funds were distributed appropriately, they weren't overbilling?
I don't know. Eric, do you know?
No, it's an interesting question. I have no idea.
Well, I mean, this is, like, I just think like from a practical standpoint, this just seems ripe for abuse. That's just my personal view. Like, I want to assume that everyone is a very good actor, but I also think while we're stewards of Vermont taxpayer money, I just feel like this, like the fact that no one knows this, and it's shocking to me.
Well, I'm sure that.
There has to be some kind of oversight.
Yeah, and it's appropriations. I mean, appropriations looks at that and presumably they also make sure that there's oversight. Yeah,
And the
so that's
meetings
a
are
question.
recorded, public.
Yes.
Yeah, all those, yeah. So I mean, I would ask somebody in appropriations.
All right, I'll talk to,
So,
I'll talk to
We're also not talking about expenses, right? It's a per diem.
well,
But where's it paid?
they get mileage.
But where's that paid from? That's paid from appropriate,
From appropriation.
right,
From-
which is Vermont taxpayer money.
Yeah,
Right. And
So they are being paid something out of somewhere.
right.
Correct.
Same way we're paid.
and appropriations,
Well, that's my whole point, Angela.
that's appropriations is the entity that
But
makes.
I'm saying
sure
it's a
that we follow that.
set, there's also like a set amount.
But Karen just said that they can ask for extensions and meetings can be increased.
Oh, no, I mean like in the per diem, it's a set amount. It's like the same way.
All
we
right,
get-
I understand that, yeah.
Yeah, so
And
But the amount fluctuates. I mean, like the overall amount that they can get fluctuates. It's the same amount paid per diem, but it could be a difference of 6 days to 12 days to a month to this thing goes 6 months. That's not, that's
Well,
my,
that's why we have the 6
there,
meetings.
right.
So that's how appropriations know that, all right, there's 6 meetings, there's this amount of money. But you're right, I don't know how.
But I just want to, is that hard and fast or is it not?
It is. That's what, it has to be appropriated for the money to be paid. But again, this is out of my lane.
Right.
This is
Right,
just from my
I'll talk
experience,
to,
but
I'll
yeah.
talk to appropriations.
Farmer.
so I know from commissions or committees that people, like there is a accounting setup. For example, judicial nominating met once during town meeting week. And it goes through our bookkeeping, the legislatures. And the statute says during the legislative session, it cannot be paid. So that was flagged. And so people didn't know that. And then each department is audited externally. There's an outside audit. Then the auditor each year picks different departments to look at in more detail. So it's the state government has a lot of systems in place with some checks and balances.
But they're not all audited every year. It's a selective. It's like an IRS audit, like we're on a.
But the people who are paying the bills are looking at the statute, or at least my experience has been they're looking at the statute and double checking to see if people can be paid, but
Yeah,
and there
I mean,
are
that's reassuring to
receipts
hear.
attached. So I'm sure you can learn more from appropriations.
Yeah, I'm gonna connect with them on that.
Karen.
Sounds like we're covered. I was just gonna say, I feel like good on this and
Yeah,
Get more information.
although, I mean, I can ask somebody from appropriations or Trevor or something, because I'm kind of interested in understanding.
To come in.
Too. Yeah.
Yeah, I was just gonna say that, because it sounds like we all need to be educated on it.
Yes, yeah, no, that's good.
Yeah, no, that's great.
Yeah, I'll get somebody from appropriations or JFO, whoever the right entity is, to come and tell us how that kind of thing is checked,
Yeah.
because that would be good to know, so.
Yeah, actually, that's a good point. Maybe someone from JFO might have that information
Yeah.
too.
Right. Cool. I'll reach out to them. All right, moving on.
Yeah, before we move on, if a question came up about audits, probably JFO would know more about that than somebody from appropriations. That's a question mark.
Yeah,
the commission.
May not, just,
probably worth asking both. I'm not sure.
okay. Just to get all the questions answered.
Yeah, make sure you get the info.
Yeah.
Okay, so.
Speaking of working groups, although that wasn't a working group, I believe it was a task force.
This is different.
What is the difference?
Yeah.
Never mind.
Great question, Ian.
Dictionary, common language.
Yes, yes.
No, I rescind that question. That question is rescinded.
I don't think there's much difference. I know that in this particular case, the Center for Crime Victim Services asked for a task force and the judiciary asked for a working group. So that's what I heard.
I think that is in fact how that happened.
Yes, but I don't think substantively it's any difference.
We'll ask Judge Zone why he's created a working group at the task force when he's.
Now want to give him a task.
Right, right. So section 33 was requested by the judiciary. In particular, Judge Zone and the probate judges as well. As you can see, this deals with involuntary guardianship. That's the subject of this working group. And I can tell you what the general task of this working group is clearly defined, and that's that under current laws, you have two different divisions of the Superior Court that have jurisdiction over adult guardianships, right? You have the probate division has jurisdiction over adult guardianships in certain situations, and the family division has jurisdiction over adult guardianships in other situations. For the probate division, it's adults who are in need of guardianship generally, and that would be, I'm just reading for the definition of the probate guardianship statute, someone who's an adult and is unable to manage without the supervision of a guardian some or all aspects of their personal or financial affairs as a result of significantly sub-average intellectual functioning, which exists concurrently with deficits in adaptive behavior or a physical or mental condition that results in significantly impaired cognitive functioning, which grossly impairs judgment, behavior, or the capacity to recognize reality. So you have this general broad definition for when the probate adult guardianship jurisdiction can kick in. Guardianships in the family division under Title 18, however, are only available for adults with developmental disabilities. So you have these two different courts with jurisdiction and adult guardianships depending on the circumstances. And the idea of this working group is to examine that situation and decide whether it's a good idea or not. Should these two different courts continue to have separate jurisdiction over different types of adult guardianship, or should it be merged? It would be more efficient and more adaptive to the needs of the people involved to have it all in one court and one type of proceeding. That's in a nutshell what this working group is supposed to look at and come back with quite specific over on page, I believe it starts on page, very last line of page 29, up over on page 30. This working group has to make a recommendation to you guys about whether or not these two different types of proceedings, this is line 2 and 3, page 20, should be consolidated in one division of the Superior Court, or down to page 5 or 6, or should they remain in separate divisions of the Superior Court as provided for in existing law? So they got to look at this. And as you may know, there have been some constituents who have brought this to the legislature's attention as well, as not only the legislature's attention, but probate judges and other folks who are wondering whether or not the system makes sense or should it all be consolidated.
And so that is relevant to H26. This is kind of a response to that bill. I ran the H26 by Judge Zone, and this was his recommendation that they have.
This is 33, section 33.
Yes.
Yeah. Is H, sorry, one more time, H26. Thank you.
Which was a proposal to consolidate, if I remember correctly.
I believe that's right.
Yeah.
Any other questions on that?
That's the last one.
Thank you.
Yeah.
All right, so now we'll hear from some witnesses as far as the various. Yes, I have. Any other questions for Eric at this point? Not seeing, Kim, if you could join us, and you're not limited to the amendments because you haven't been in here before, but.
That's a per sentence.
So if you identify yourself for the record and start walking through and give us your input.
Thank you. For the record, Kim McManus from the Department of State's Attorneys and Sheriffs. As the chair noted, this is our first time in on S109, so we are going to walk through the original bill and then shift into the amendments. And then we do have two considerations that we'd like to put before you to possibly add to the bill.
The original, you said original bill, meaning the first 17 pages.
Exactly. So right up to page 18, and then we'll switch into the amended bill. Thank you. So obviously only touching on the sections that would impact our department. There's plenty in here that is very far outside of our lane. The first section, section 8, the removal of switchblade from the statute. This, of course, is a choice of this body to decriminalize switchblades. We have no position on this. We heard Judge Zone's testimony that I think it was something less than 20 cases to this. So no position. The piece about expunging the convictions, again, because it's such a low amount, we're going to be able to, that's not going to impact our expungement workload. You've heard plenty about our expungement workload, and you'll hear more about it when S12 comes up, but decriminalizing switchblades is not going to have any impact there. We have a little back-end work that has to be done anytime these changes are made, but nothing too complicated. So the expungement date of July 1, 2026, that's doable. Section 18 for pre-charge diversion. We understand the clarification there that state's attorney just noting that they may include pre-charge diversion as one of the many options of sending a child to a community-based provider. We have no issue with that. Section 23, and I apologize, I'm not saying page numbers. Is that annoying?
No,
Okay, sorry.
I can just find the section.
Okay, great.
Sections, page 17.
Thank you. Just moving through a little faster. Section 23, the inebriate bill. We defer to law enforcement on this. We understand their need to have Department of Corrections as an option, but we take no position on that. Which moves us to page 18, the amendments. For section 25, the firearm surrender working group, we appreciate the simplification of the group. Anyone who's worked on a committee knows a committee of 16, that's a lot. But of course, we did appreciate the consultation. So we are a member of this working group and we appreciate being on it. And then we will consult with our victim advocates and our sheriffs as part of our department. So we feel like we are represented fairly there.
All right. Yeah, go ahead. This, I mean, you were in the room, Kim, so I wouldn't ask you to respond directly, but one of the considerations that the group was just discussing was moving some of the different parties on the consultation group into the working group. Do you have any recommendations on which ones you think we should consider? Or let me rephrase, are there any potential gaps that you think that we're missing that should be on members of the working group over the consultative group?
I don't think so. I have to admit, I did not
okay.
analyze it in that way, and you might want to have Carolyn Hansen
Sure.
back in. But I imagine that she may have been possibly consulted on this. You know, from my experiences of being on working groups or committees, or working groups, task force, whatever you're calling them. When the statute says that you need to consult, that is taken seriously by the committee. And so you'll see in reports how folks were consulted and feedback that was given and how that was done. So I do feel like that is a real consult, like it's not window dressing.
Okay.
Or whatever that's worth.
Yeah, I think the concern that I have that I think other members in the committee might share is making sure that any of the viewpoints that are consulted on are outweighed by the members in the working group with the end report coming forward. So that's just a consideration. That's why I'm asking the question, the consideration that I'm having.
No, and a fair point that the working group is going to steer and create this report. And so
That's my
balancing out
point,
the
yeah.
working group is something
To make sure that it exhibits diverse perspective.
we to
Yep.
consider. Section 30. We want to appreciate the addition and the clarification that state's attorneys, prosecutors in the state can appeal when a motion to revoke is denied. As was mentioned, this conversation came up during H409, the bail revocation bill, and there was a discrepancy there in thought of whether we could or not, even within our department. So we appreciate this addition, and we thank you for that. And we, of course, then support it. Section 31, the notification of earned time to defendants and victims. The earned time issue, conversations with victims is it's always a tough conversation explaining earned time to victims. And so, any improvements in notifying and updating victims about that change and how much time is accumulating or when a minimum is coming up, I believe victims would very much appreciate that. And the fact that it's worded that they can opt in. Again, victims feel very differently about how they're contacted and about what they're contacted. And you would hear, there's been a tremendous amount of testimony on this in House corrections and institutions about the victim notification system. And you'd asked Representative Arsenal, about the process, and Department of Corrections would be able to explain that best. But victims do sign up for the notification, and then how much that can be tailored to the person, I think that's a question for DOC, and I think that's part of the work group that is in section 32. But so we have no issues with the changes in section 31 and appreciate that we're trying to improve the notification to victims in this area. Section 32, the Victim Notification System Task Force. Again, if you have not had the opportunity, there's been at least 2 days of testimony and corrections and institutions of some very compelling testimony about the current system and about when it's working and when it's not working, and the impact that it has on victims when it's not working, where they're not receiving a notification or receiving an error. And then not able to talk to a person about that, say over a holiday weekend. One of our victim advocates testified on that. So if you haven't had a chance to look at that testimony, it will, if you're questioning whether this work group task force needs to happen, that testimony will probably make you feel that this is very necessary. And we appreciate from our victim advocates, appreciate this closer look at the system and how it can be improved.
So so we should probably have those witnesses in ourselves. And can you get me a list of who those people are and their contact information?
I can, well, from our department, I can easily give you that. I'd have to quickly look at the list. It was just from April 2nd.
Oh, okay.
Was the last day of testimony, but Jen Pullman testified. There were 2 or 3 individuals from Department of Corrections whose names I'm not.
Okay, no, that's fine.
But we can just pull that up.
Yeah, we'll look at their agenda.
Mhm.
Okay.
But it will highlight the need for this, I believe, for all of you, and we support this as a department.
Kim, we talked earlier in the session about utilizing Odyssey to notify victims of court dates, things like that, and like whether it was a good idea or not. Does the task force or working groups charges here, do you think that 3 sort of like captures potentially using Odyssey? I don't really know what the automated notification system is that is being referred to. I just think it would be worth them thinking about Odyssey as well as part of the discussion.
So the current automated notification system of the Department of Corrections is called Vines Linked. It's the long name. I do not believe that this is contemplating Odyssey as part of that. And it's important to know the prosecutor's office and our victim advocates, we have a duty to keep victims informed of court dates, hearings, everything within the victim's rights parameters. Signing up for this system is a separate piece. So this is something from the Department of Corrections. A testimony that was given in corrections and institutions is that sometimes if it's too much for a victim to get these automated messages directly, what our victim advocates will do is they will sign up to Vines for that person so that they get the alert. so that then our victim advocate, a human voice, who has some context to what the message is saying, will call or email the victim, depending on how they've set up their communication. So this automated system is specifically through the department,
Yeah, okay.
as far as I understand.
All right.
So that is the amended portion.
Can I goes back a section, to the bail revocation denied. It's expedited appeal, I guess we could call it. Does the department have any sense of, potential racial implications? Do you keep any data on, bail revocation and the race data on defendants in that context?
In the judiciary might, in our database, we wouldn't, unless race was noted on in the affidavit in some way. If it's not a criminal record, it's there, but it wouldn't come up in the pleadings for the revocation. So I'm not quite sure where we would pull that from if we were looking at whose bail is revoked and
Right.
whose is not. That would be a better question, I believe, for the judiciary.
Okay, thanks.
Whether they could access that data,
Yeah.
that I don't know. Okay, now the part where I was talked about earlier, whether this bill grows and grows and gets a little longer. We would like it to get a tiny bit longer. So we have two requests for you. And this has been submitted in writing as well, but I will just briefly review. We had, there was a bill H 410 about the definition of recidivism and about how we calculate and capture data around recidivism. It's our understanding that H 410 is likely not going anywhere right now, and we understand it's a larger data question and a data question that we very much wish to be involved in. Attorney Paul, I believe, I can't remember which bill we were in on, but was speaking about the need to have a group, really look into who has what information, how can we share it, how can we pull this information, right? Like this just larger data conversation, and we are not requesting a working group. Representative Harvey?
Don't worry, I'm listening.
I know.
Well, listen, I just want to clarify something. It's not that I'm questioning the intent of what the working group is looking to accomplish, because there's a reference to that. I don't question whether they're important and they're going to do very valuable and rewarding work for the people of Vermont. The question is whether I think Vermont taxpayers need to compensate those people.
Understand.
That's my only point.
Well, and if we very much want to be part of that conversation, if this committee decides to set something up like that. And a little bit to your point, Representative Harvey, we would see that group being state entities, so there wouldn't be that
Exactly.
outside
Yep.
piece. But we would love to engage in that if you all wish to consider that. However, our ask is, since we are not ready to wrap our hands around all of 410, if you would consider changing the definition of recidivism as was requested in that bill. Currently, the definition of recidivism is tied to incarceration of more than a year. And we're asking for it to be tied with a conviction. So after having a criminal conviction, you have another criminal conviction that would count towards recidivism. This would capture those who do not have an incarcerated sentence in Vermont, which is the vast majority, right, are either put on probation or might have a fine-only conviction. And we would like to be able to capture that. We feel like it's misleading right now when we speak about recidivism, and that we often in this room and elsewhere are using recidivism, meaning someone having a conviction again, but we're not calculating it that way. We're calculating incarceration. So we would ask you to, and again, this is all written down, so I'm not going to read it verbatim right now, but we'd ask you just to take a look at that to see whether you would consider that change. If that change seems like too much right now, like if you all cannot collectively agree to that, we would ask you to look at, and this is all in 28 VSA subsection 4. Right now, it says standard measure of recidivism, and then it has the definition tied with incarceration. If you're not willing to change right now the definition of recidivism, we would ask that you change that section and take out recidivism and call that standard measure of reincarceration, because that's what's being calculated there.
So your first ask, it has no ramifications for anybody who's committed a crime, right? It's just data.
Correct. It would not, right, it does not influence an
Right.
individual. Now, a question for the Department of Corrections, who currently has a dashboard that is connected to that statutory definition, is whether they can capture that data and report that, the conviction data. We believe that they can. There may need to be some additional communication between the judiciary and the Department of Corrections to do that. But no, it wouldn't have it's for data purposes.
So has this ever been asked in the past?
So this was brought up in H 410.
Just this year?
Just this year.
Right.
Now, I don't know if it's come up before, so I have to be careful there.
I don't remember. So doesn't sound like there's any real pushback. It's just a matter of finding a way to compile information.
I
Which
think,
may be
and I wouldn't want to
a form of
speak,
pushback,
yeah,
but-
I don't want to speak to anyone else about the definition. I think we all agree that the definition is not capturing how folks are colloquially using the term recidivism. Now, I think there's some difference in opinion of that definition of recidivism. I'm forgetting the woman's name who spoke to you all who, no, not the, yes, thank you.
Sorry, who is it?
Oh, right.
Yes.
CRG.
We said, you can use arrest date, like an arrest as recidivism. You can use incarceration. Conviction sort of lies in the middle as a reliable data point. Whereas, so there is conversation around the definition. We think this is a good middle ground for now to better capture what is happening as far as folks getting convicted again.
Yeah, to me, arrest doesn't make sense, but conviction would. That's just.
And we agree.
So I mean, the other alternative could be to do both your second and third, keep the standard measure of incarceration and then add for the recidivism. Because there may be other things that measure is being used for. So, I mean, I now understand a little more from where that came from, although this is probably now very much hearsay, that there was a certain senator at a national meeting and they're talking about recidivism, and our recidivism rate looked really bad because we apparently measured it differently back then. And so he changed it to be incarceration to make our recidivism rate look better in comparison with other states, which were also doing it based on incarceration.
That sounds like a lot of hearsay.
That was a lot of hearsay. I preface that by saying it was hearsay, but it sounds like it's probably true. It sounds like that's the kind of thing that could have happened. In any event, so you have language,
Yeah, so the language is in, we submitted a memo earlier today to the committee.
Oh, I'm sorry, and Ian had a question.
No. Oh, I didn't want to interrupt. Were you? Yes, sir.
Yeah, I'm sorry.
No, I believe we have submitted the language, but happy to work with legislative counsel if this is something the committee supports. If there's some tweaking within the statute, we're happy to further.
So on the recidivism, so it's kind of funny because we're basically saying recidivism and defining it is pretty complicated, but then you want us to define it.
Well, I think it's a choice of
Yeah.
where you're drawing the lines. And I appreciate that the whole data collection
Mhm.
is highly complicated, and we in no way are saying this figures it all out. We do think it's an initial step.
And so I think my one question on your language is, you strike everything, including the timeline. So like,
Oh.
yeah, the
mhm.
3-year look back and all that. So you don't think that would be beneficial to have, but just look at conviction and not incarceration? Does my question make sense?
It does, right, so the current definition has a, within an X amount of time to count towards it. From our department's perspective, again, we think the more accurate reflection of recidivism is a conviction after another conviction. Now, I believe these studies are done in 3-year look backs. So I don't, and part of it, if you go back to 410.
Yep.
There's a very thorough sort of pulling out years, like giving chunks of years to see.
Yeah.
Like, did someone recidivate within 1 year, 3 years, 4 years, 5 years to study it? So we think keeping the definition like this just keeps that open. Now maybe you'd want a cutoff point,
Mhm.
so to speak, that someone sort of restarts. They're not a repeat offender if it's after 10 years.
Yeah, I guess because
But that's up for
if
you.
if it gets pulled every 3 years, but we use the language that you propose, then in the last 3 years, if you had somebody who hadn't had a conviction in 20 years, but then got convicted in that 3-year period, then they would be considered, they would be captured in this definition.
Probably. Yeah.
Okay.
Yeah. So yeah, the timing, that's definitely something to think through.
Okay.
So I should probably know the answer to this. So we collect all this information, recidivism rates. What do we do with it? I think I know the answer, but I think it's got to do with corrections, rehabilitation and that type of thing, but.
Well, and part of it is right now, again, this is connected. DOC does collect this data. They analyze it on their website. There's an excellent dashboard. It's very interactive that you can go in and look at this in what we would call an incarceration rate. And that's now what DOC, I don't know what they do with that as far as whether they look at someone's recidivism when they look at furlough or parole, that I would not know.
I mean, I'm not concerned if we look good compared to another state myself. Or I'm more concerned what we do with the information and if we're using it for good. Other than just to have the information.
Is it possible to get what the language was before it was changed?
Yeah, I think we can track that down. Was it in the statute? Does anybody happen to know?
Oh, no.
Well, we can figure it out. Yeah.
What should be like exactly?
Imagine.
Okay, moving on to.
Right, so we have one more ask this committee to consider. Just one more. If you all possibly recall H409, the bail revocation bill, in that bill, there was an amendment to the statute that changed the word impede to disrupt as far as prosecution. It was in subsection A2, 13 VSA 7575. We understand that 409 in its entirety is not moving forward right now, but we would ask that you go back and take a look at that one section of changing the word impede to disrupt, as this would align with current case law. And if you decided to do that, we would like to add a definition for disrupt the prosecution. And we had submitted that in writing to the committee, and it's in our memo, so I won't read it to you right now. But if you could consider that in the miscellaneous bill.
But while I have you there and about that, having, I mean, we can get the language out so everybody can see it. But the question I will have for you though is, it seems like it's going to be fact dependent And you can make all those arguments, and if your motion's denied, we're giving you a way to get it to the Supreme Court to consider that, whether that language, because even if we put that language in, it's going to be the same path. It's going to be the same path to have the Supreme Court decide whether, in fact, that's constitutional or not. So why don't go ahead and find the right case out there and make just that argument that you have under disrupt and connect it to integrity of the judiciary or inability to prosecute. We can solve it all.
Maybe.
I'll get the we'll put the language out for everybody to consider. So that
We appreciate that.
see what I'm talking about.
And again, just to note in that conversation in 409, when everyone was looking at bail revocation, we had talked about, that giving a little more guidance on what the legislature believes is disrupt the prosecution. And I understand there's a fine line there that you all do not want to cross, but that it does help signal to our prosecutors that this is something that you want us to look at and then to do. So just one little plug there for it.
The right to appeal, the denial of a good signal for prosecutors to pursue these fact-based bail revocation claims.
I will happily highlight that at our training. But while we're being slightly greedy with our two apps, we would ask for the definitions.
So what we'll probably do, my suggestion is it'll be one step away from the miscellaneous bill, that we will put that amendment into H 409 and we'll look at it in H 409. And if everybody thinks this is hunky dory, we'll put it into the miscellaneous bill. But you're seeing some people who need to be convinced that it's.
Understood.
So thank you very much, though, for bringing that up again.
Thanks.
Thank you.
And
Thank you, Kim. I'm fearful of taking a break because, we'll end up 30 minutes later and I've got people online and such. Ken, can you plug through, keep on?
5 minutes.
5 minutes? That is impossible.
Warm and stuck
Go for
in.
2.5, you get 5.
All right, 2.5 minute break.
Sit here with the door open. Okay.
A 1 minute break. How French?